Hello, everyone. It's Rob Ryder. It's Sunday, February 3rd, 2019. Super Bowl Sunday, as a matter of fact. Today, something that should be near and dear to anybody who believes that they own property. It's the earnest money and the closing protection letters. Warning, ye are not the owner. Agent did not transfer title. No, didn't happen. No. It has not happened. And I'll show you why. Note to ye, if title did not transfer, right? If A, it's right, well then, ye are not liable for the property tax, which you're not. If you were to look at the property tax bill and look at the name that's on the warranty deed or whatever you think makes you the owner, even though not all the steps have been done so that can have any validity, but nevertheless, you look at the two names, they're not the same. Right? So you say, no, this is the name on the warranty deed. That's who you would need to be taxing, and that isn't the name they use. And hey, this is a big find. This is huge, man. You got to pay attention to this. Finding the real residence address on the land, not the mailing address, the residence address, which it turns out is your lot number on a plat map. That is what I believe, and I'll show you why as we look at some of these documents that have to do with the thing that happened first in a real estate transaction, right? The buy-sell agreement. That's the document that has everybody's signature on it. It's the contract. It is the law of the transaction. And in there, it says you can go to small claims court for earnest money issues. And you say, well, yeah, but I want everything, blah, 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 blah. Forget that for a second. If we can agree that you went for an earnest money issue in small claims court and you won, that would be evidence that the deal never happened, right? So the contract had never been fulfilled. But you can also do it, you can also sue for specific performance. Now that's through small claims court. But prior to that, the way they have the system set up is that through the realtors, right, capital REALTORS with the T in the thing, right, that's an entity that has their own code of conduct that all these realtors that we deal with are part of. And anybody who works for a realtor as another agent is bound by. You know, they have their own law, basically, and the realtors, and they have through mediation and arbitration. And so just a couple days ago with Terry, I had written a fax for her to send to the arbitration people or to the Realtors Association, where she lives in Wisconsin, you know, making known certain facts, which we'll get into, I'll show you in just a bit. And then the next day she called them and talked to them, and had it not been for the fact that the ombudsman was on vacation, they would have had this person call her. So I'm assuming that will happen next week, or they're lying, right? But they said they would have an ombudsman call Terry. And this all goes back to the fact that, like in her case, there's no evidence that there's a receipt for the real estate transfer fee, which was supposed to have been paid by the seller. Okay, well, there's no evidence that she has that that's ever happened. So if that didn't happen, then the title has never been properly transferred. That's one way they do it. Right? So not every state's the same, but the place to find this is all on the buy-sell agreement because it says on there how you're going to transfer the freaking title. So let's get into it. Rob Ryder's email address is courtofrecord@aol.com, and my phone number is 616-712-6179. I really need you to donate. Please donate. Look, I'm 2 months behind on my rent. I don't know if I can pay my cable bill next week. So help me out. My PayPal account's robryder@aol.com. Or ask me for a money request, right? Send me an email, and I'll send you something from that says I'm going to, or it'll be coming from PayPal. For a money request, it would allow you to use your credit card or debit card, or you can put it in the mail. Robert Allen Rytlewski, RYTLEWSKI, 10955, 14 Mile Road Northeast, Rockford, Michigan, 49341, 8664. That would be a mailing address. I'm not sure what my lot is in my plat yet, but for me, I believe I'm going to find that at the Township Hall. So I'll be talking to them on Monday. Hey, side note, you is plural. If you didn't know that, I'm going to call you you all the time, but, it's actually ye. So if you go to court and the judge says you, you say, I'm not a you, I'm a ye. There's only one of me. Because by you would mean there's more of you. Right? There's more than one of you. And that's what they do. They make an uppercase version of your name and a proper case. And they say one is your business and one is you. And I know that to be a fact because I got an EIN in my name as a sole proprietor. Where I said the name of the business was Robert Allen Rytlewski and the name of the owner was Robert Allen Rytlewski. The IRS agreed and gave me an EIN number. Right? So there's two of me now. So what are you going to do when you know you've been made two? Right? You're going to find a way to connect yourself to one place. Because there is two of you. There's your business, which you need to operate in commerce. And then there's you, who's the owner of the business, who needs to, function in the world. And they have us disconnected from the land right now because we're not on the frickin' deeds. Right? You're not in the United States. This is what happened, right? You're not in the United States because they didn't transfer the title. And I've talked about this in numerous other videos. I've shown evidence of it. It's very simple. That's what's happened. You're not in the United States, so quit bitching about the United States. It didn't do it to you. Somebody is saying you're not in the United States. And when I say you're not in the United States, I mean you're not in the territorial boundary. You're not found there by address. Because we're not connected to the land, we're connected to some frickin' fiction. Through a mailing address and not the land address. For I tell you, unless your righteousness exceeds the scribes and Pharisees, you will never enter the kingdom of heaven. Thank you, Jesus. That was Matthew 5:20, and that's what we're dealing with, right? These people aren't very righteous. They lie, they cheat, they steal, they act like they're Old Testament Jews. They take you to the court of a false accuser. They cheat you in business. They're working under Talmudic law. And I'm not saying they're Old Testament Jews because there aren't any Old Testament Jews, right? They're people who are pretending to be Old Testament Jews, right? They're the false Jews. And the way you can tell they're false is because a real Jew in the Bible, according to the New Testament, right? Well, and not just according to the whole Bible. I'm going to say that your Jewishness came from your father, right? They have Jesus' lineage by men all the way back to Adam. However, you go to a Jew today and they got theirs from their mother. Well, then you ain't the same Jew as the Old Testament Jew. And I don't know who you are. You don't have any claim to anything. And there are no Old Testament Jews. See, this is the thing of the flipped over system. Right? And that's what we're finding ourselves in. So, instead of arguing with them about it, because you can't do to them what they did to you, because two wrongs don't make a right, we need to be as wise as serpents and gentle as doves. And we'll just, do it with paper. So we'll get the paper figured out. Because that's where the error is. The error is in the record. If the record was correct, we wouldn't have an issue. But because we hired an agent to do it, it's not our fault, it's the agent's fault. That's this thing called agency. And so let's look at a couple definitions real quick and we'll get into this. And this may take a while, right? You may want to go get a cup of coffee or beer, soda, whatever, and because I'm going to cover a lot of things, and they're not necessarily going to be in any particular order. And you may have to watch this video 2 or 3 times or more to understand what I'm talking about. But, that's okay. That's how it should be. I didn't just read this stuff once either. I've been reading it for weeks and weeks and weeks. And I'm going to try to condense a bunch of little pieces of a puzzle into, a Reader's Digest version. And here's the chunks of information that somehow we're going to tie together to get a remedy. But it starts with knowing what tools you have to work with. And, so one is earnest. What is that? That's the payment of a part of the price of goods sold, or the delivery are part of such goods for the purpose of binding the contract. And in a buy-sell agreement, you're going to put up earnest money. Well, that amount of earnest money will be low enough that you could go to small claims court to put a claim in against it. See, that's the thing, right? And it's based on a contract. Well, if they give you back the earnest money, that would mean that the contract wasn't any good. So if that contract said that you were going to be paying somebody a bunch of money every month, well, that contract never happened, so give me back my payments. That money's been going into an escrow account, right? Because, nobody ever lent you any money. If you don't know this, and this may be news to you, but, if you were following my videos up until now, you would know that nobody has lent you any money. Go look at your deed of trust or mortgage. You're the only one that signed it. And that is not a contract in business. The only contract that I've seen so far where everybody has signed is the buy-sell agreements that are done with the real estate broker, who is an agent, has an agency relationship with you, which means they have to give you, basically full faith and credit. Well, what does it mean? Contract's an agreement, express or implied, by which one of the parties, called the principal, that would be ye, confides to the other, that would be the broker, which is denominated the agent, the management of some business to be transacted. What is it? It's a transaction, right? That's what it is. It's a business transaction in his name or on his account, and by which the agent assumes to do business and to render an account of it. So that's what the broker is to you. They're transacting business in your name or on your account, right, for you. They owe you an account of what they did. And, well, it hasn't been complete yet. Agent practice. An agent is an attorney who transacts the business of another attorney, right? Now, this is like a different definition of agent, where this agent is like the closing agent that the broker would hire, right? Somebody called an agent. Where an agency, they just have this style of relationship between somebody known as an agent and somebody known as a principal, right? But that's agency. So this is how they, start changing what the word means. Now that, if you're just talking about an agent, well, that's an agent is an attorney who transacts the business for another. Well, this is who your broker is going to hire to do the closing, be a closing agent, right? So they're actually doing the work. But you've transacted to do the business through your broker, who is the one you had the agency relationship with. So if this agent that's doing the closing screwed up, it's not your fault, it's your agent's fault. The agent owes his principal the unremitted exertions of his skill and ability, and that all his transactions in that character shall be distinguished by punctuality, honor, and integrity. In other words, the dude's got a fiduciary duty to you. Agent, one who undertakes to manage some affair to be transacted for another by his authority on the account of the later, who is called the principal, and to render an account of it. That's who we're talking about. That's who your broker is. Now, in real estate, they have two levels of licenses, I guess. They got an agent, the one that takes you out to show you the house, and they got the broker. We're talking about brokers, right? They have the power to transact the real estate transaction. And they got somebody else to do the closing who didn't do everything. There are various descriptions of agents to whom different appellations are given according to the nature of their employments, as brokers, factors, supercargos, attorneys, and the like. And so I would say the same thing. If you're going to court and they've given you a court-appointed attorney, tell them you want to have an agency relationship with you and sign a contract. That you're making them your agent, not your attorney. Right? You need to have an agency agreement. That's the contract where both parties sign. Not this bullshit where only one of us is signing, which is always us. Right? That's a unilateral contract at best. And that can only be used for gifts and donations. So it does not have any validity in in court. And there's just all sorts of, hey, they got a lot to say about agents. Go ahead and read it sometime. Okay, give me just a second to get some documents up here. Okie dokie. Let's start with the revelation of the week. My lifetime, actually. Thank you very much. For me, at least, is this, that here's somebody's settlement statement, right, that he got after the fact, right, in Jeepers. I don't know why it puts that on there. There we go. Right, this property location had been altered. Like, underneath here is the street address that he would have thought it was, and they put on top of it lot 515, right, point Tapatio 6. Well, that's the address of the property, right? That's the residence address. It's not the mailing address, but it's the residence address. And that gets tied to a plat map. That's why I'm saying, if you go find the plat map, because what these are government lots, right? This is how the government would know you, because this is all done under the public land survey system, which is how the federal government gave up the property in the first place. And so it isn't your mailing address, it's your residence address, physical address. And so if you were to look, when you go to do a driver's license, they want your physical address, and then they say, is your mailing address different? Yes or no, and then put it in. That's what I'm talking about. This dude's real address is lot 515, Point Tapiato 6, Phoenix, Arizona 65020. That's his residence address. And what's his mailing address? Well, whatever it was that we've covered up so you can't see it. And so even if you're a renter then, like me, I don't actually live here. I don't own this property, right? But it still has a property address. I should be able to get it from the township hall or whatever jurisdiction I'm in. And I'm going to put it on the change of address card for that you do for your mailings for postage, right, through the United States Postal Service. Because, again, this is all federal. This will get you tied into the federal. Then it's like, well, that's outstanding. And do the same thing in my driver's license with a different, whatever my mailing address is. Very good, I say. And so going along with this, I mean, the same gentleman that got this was another document he got. He had done a cash purchase back in 1997. Right, and the deposits, the required documents and funds by the buyer or seller shall serve as evidence that all matters and contingencies for which escrow holder is responsible have been fully met and waived. Right, so was everything deposited and all the funds and so forth? I don't know. Buyer and seller have closing protection in the form provided by ARS, Arizona Revised Statute 6-841.02b. We'll have to look at that later. And 6.834d. And I'll show you why later, because these are sections that all add to what has to be on the documents to prove that it's been closed. Right? So in the meantime, in order to comply with this and to further comply with the intent of the Attorney General opinion, which we should probably look at, issued on September 6, 1979, notice is hereby given that the escrow agent shall select the depository of all funds to be delivered to the escrow agent unless otherwise agreed by and between the escrow agent and the party to the escrow delivering such funds to be deposited. And all benefits and values derived from the same shall be to the benefit of the escrow agent, unless otherwise agreed in writing. Which means this guy, the escrow agent, is going to take any money you give him and put it in an account, and he's going to keep the interest until it leaves escrow. So would you believe it's in his best interest to keep it in escrow? Absolutely. Well, this escrow agent is the one that your agent's going to hire to do the deal. Right? So the escrow agent's not going to close the frickin' thing, and he's going to be keeping all the funds. Yeah, it's a crime. That's what they're doing. Sure, I know it's a crime. It's it's fraud. But that's what they're doing. It's at the title company. Right? The one doing the closing. Not your broker that you bought the property from, but the one that did the closing. And so here you do the closing at like the title company. And well, wherever you would do it, you would do it. But it went on to say you do have the right to have the funds deposited into an interest-bearing account for your benefit. Right? So it can either go to the broker or the escrow agent, not your broker, the escrow agent, or it could go to you. The charge to you for Grand Canyon Title Agency Incorporated to establish any interest-bearing account for your benefit is $25, assuming a 5.5 interest rate, blah, blah, blah. It could vary. For every 1,000 deposited, the account will earn $4.58 of interest per month. Right, so how many tens of thousands times that would be what was going into your account every month? And well, John has checked on these, and apparently this account has a lot of money in it. We'll get into the financial details of it all, but it's worth pursuing to find out, well, did this thing close or not? Because if not, even if this guy put it into an account for his benefit and it drew more interest, it's still yours because it was done in fraud. So, this is why it all matters. Well, did the closing happen or not? And what did I want to show you on Jeff's? This is just kind of more like a straight up purchase contract, right? Between somebody selling property and somebody buying. Buyer and seller. Who's the buyer? Jeffrey S. Jacobs. And who's the seller? Dustin S. Axtell. Right? And there was $1,500 in earnest money put up. So that's the thing that if you had to, you could do foreclose, or you could go to small claims on, is the earnest money. Because all earnest money claims can be heard in the small claims court, which means they can't have an attorney. You can't have an attorney, they can't have an attorney. What you need to have is, a copy of your contract and some evidence to show that it's never been done. You want your earnest money back. And they'd say, yeah, but escrow closed. Well, then I want title insurance money. Right? This would just establish the proof that you were due a claim on the title insurance. It's a foreign judgment, for lack of a better term. And we'll get into these more details here shortly. But what I did want to show you something here first. So this is 9 pages long. There's no need to rush. I'm going to take a breath. Go slower. Somewhere in here it should say where we're going to close, or who the closing agent is. Close of escrow. Financing. Title and escrow, right? Who's the escrow agent? Title Security / Catalina Title. They are. They're the ones that are acting as the escrow company in this particular case, where it's just a straight up sale. So anybody in Arizona that bought residential real estate with a purchase contract, there'll be somebody on 3A and line 91 of these contracts that have been, put together by the REALTORS Association. Right, realtors. And then notice all of these are electronically signed. And so I've talked to Jeff, who's this is, and no, those aren't his initials. Right? This is electronically signed. He may not have ever even touched this document. Somebody did it for him. But what it says to do, so this is where you find out, well, how do you know if the title's been vested? And it says, seller shall convey title by warranty deed. And we'll look in a little bit to see what that means, but basically it has to have certain phrasing in the document that's claiming to be the warranty deed. In other words, it needs to say it warrants and conveys. And when you look at the thing there in Arizona that they're recording, it calls itself a warranty deed, but it doesn't say it warrants. It just says it conveys. So it doesn't meet the criteria. Right? Now, We could argue about it with them, or we could take it to court and have it figured out. Or we could go to arbitration, or what these other things are that they have available. And then there's additional instructions, right? So here's all these closing instructions. And one of them is a closing protection letter. Escrow company shall deliver to the buyer, seller, upon deposit of funds, a closing protection letter from the title insurer indemnifying the buyer and seller from any losses due to fraudulent acts or breach of escrow instructions by the escrow company. So where is the buyer's closing protection letter? Now last week, who was I talking to? I think it was Terry in Wisconsin. She said when she talked to her broker, she said, well, what's a buyer protection letter? They never heard of it. Buyer's closing protection letter. Because this really isn't something that your real estate agent deals with. This is all being done by the title company. Right? So what the realtors are doing, they're doing things by custom, not necessarily the law. However, because there's this protection letter, they're indemnified because they're acting as the buyer, right, from the fraud of the closing agent. But the closing agent still needs to pay because, well, they violated the law. All we need to do is put our claim against our agent and tell them to go, do whatever they need to do. So an overview of closing protection letters for title insurance. This isn't very long. I think I'll just read the whole thing. So, with real estate prices mired in the doldrums and buyers walking, this is from 2011, by the way, so that probably doesn't matter. What is a closing protection letter? Closing protection letter, sometimes insured closing letter, right? Insured closing letter, or CPL, forms a contract, a contract between the title insurance underwriter and the lender, in which the underwriter agrees to indemnify the lender for actual losses caused by certain kinds of misconduct by the closing agent. Title underwriters often authorize closing agents, to issue these letters to lenders when the closing agent anticipates issuing the underwriter's title insurance policies in the transaction. An ALTA form, various state proclamated forms, underwriters' own forms, and custom letters have all cropped up. Most letters explicitly make third-party beneficiary out of the borrower. Right? Most letters explicitly make a third-party beneficiary out of the borrower in a purchase transaction. Well, that would be you. So it doesn't even need to be to you. This is the thing. It doesn't need to be to the buyer. There just has to be one, and the buyer's indemnified because he's an agent, or he's a principal of somebody's acting as an agent. What does the CPL usually cover? Typical closing protection letter provisions cover failure to follow written instructions. That'll get you court-martialed in the military. To the extent that the instructions affect the validity, priority, and enforceability of a mortgage lien. Yeah, I'll show you how that is tied into this. Requires a closing agent to obtain, but not to vouch for, validity or effectiveness of a special document. Right? Require the closing agent to obtain, but not to vouch for the validity or effectiveness of a specific document. Well, that would be the warranty deed, which he's going to have, now the closing agent's going to have that done by an attorney. Right? So we just keep moving this thing down the road. So now he's been identified. Relate to the collection of funds due to the lender, or fraud or dishonesty in handling the lender's funds or documents. Well. Let's just go find out. That's the great thing. We don't have to, talk between ourselves and try to figure it out. We just need to go try it and see what happens. Then we'll know if it works. But there's the reasons you could. And I'm saying those reasons all exist. So go do whatever you can with the closing protection letter. What other significant provisions should we be aware of? The letter usually caps liability at the face amount of the title policy. Lenders must make their claims within a certain time of their loss. Some letters provide an absolute time from the time of closing for making a claim. The the letter typically provides the underwriter with subrogation rights that it prohibits the lender from impairing. What are the most important CPL issues and cases? Though these letters have been issued all around the United States for at least 40 years, right? These letters have existed, so chances are, no matter how long you've been in your house, there is a closing protection letter. The body of case law interpreting them remains remarkably small, right? Been used for 40 years and hardly anybody's ever bringing it up. That's what they're saying, right? Why? Well, because they're not telling you that you're on it. And you're the one that needs to have access to it. But with expensively represented lenders aggressively pursuing these claims, significant new opinions are becoming more frequent, blah, 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 blah. I can't see any reason you couldn't take this to an attorney and tell them and they wouldn't gobble this up because, it's a slam dunk. I know people don't want to use attorneys. We all have a bad taste in our mouth about an attorney, but give them the right information, maybe they could do something for you. Because the way this starts, when you look at, let's look at this contract. So here's the contract again. Somewhere in here, it will tell us that if there's a dispute, what you need to do. Right? Because that's what we're talking about. Okay, well, what if we don't agree with you? Well, you have remedies. Right? For breach. Alternative dispute resolution. Buyer and seller agree to mediate any dispute or claim arising out or relating to this contract in accordance with Realtors Dispute Resolution System. Well, what is that? Well, Google it. Realtors Dispute Solution System. I bet you they have something you can look at. In other words, though, you're going to mediate through them. And so, cutting to the chase, that's what we did. We sent a fax over to a Realtor Association and said, hey, there's a problem. We called them the next day to reiterate, hey, there's a problem. And they said, hey, we'll have an advocate, not an advocate, ombudsman contact you. Not to get the definition for ombudsman here. Exclusion from ADR. The following matters are excluded from requirement of ADR hereunder. An action brought in Small Claims Division of Arizona Justice Court up to $2,000, $2,500, so long as the matter is not hereafter transferred or removed from the Small Claims Division. So that would be for the earnest money, right? No, you don't have to go to ADR if they don't want to resolve it because they're trying to hide themselves. Well, then you could take it to small claims, make it about the earnest money, and make your agent, your broker, the defendant, right? So who's the agent's, or who's the buyer's broker? Well, on here it'll actually tell you. But before we get there, it'll be on the next page. If you have one of these, you want to look to see where it talks about notices, right? Unless otherwise provided, delivery of all notices and documentation, right? All notices and documentation required or permitted hereunder shall be in writing and deemed delivered and received when and addressed to buyer as indicated in section 8R, or seller as indicated in 9A, or escrow company as indicated in 3A. Well, what is in 8R? Who's going to get the buyer's mail? 8R, broker on behalf of buyer. So any mail that was going to come to you as the buyer is going to be mailed to Kimberly Jubaz, agent number, This whole thing is an address, right? It's going. This is like a brokerage account because there's only one of these like this. And they're acting as that's how the mail was sent to you. Any notices, any documents, that would be title insurance, that would be, hey, the buyer's closing protection letter, anything that could be hand delivered by electronic mail and addressed to the buyer as indicated in Section 8R. So this is how they're addressing your mail, right? Things that were supposed to go to you are going here as you. This entity here is acting as you, this broker. Can you imagine? The righteousness of the scribes and the Pharisees. It ain't very much. But that's, this is what they do. And so we're going to make them undo it. And the thing about small claims court, there was a guy in Montana freeman, went to prison for a long time, who had said that the small claims court, that is the king's bench, right? In the English common law, that would be the king's bench. And I could see where that would be, because this is going to be for a real contract. All the other things that we do, they're not really contracts because both parties haven't signed. Whenever they take you to these fictitious courts, both parties haven't signed anything. They're charging you for things that have nothing to do with you. But it's all because this wasn't done first. This contract hasn't been executed. And see, it's been signed by the seller. It's been signed by the seller's representative. It's been signed by the buyer. It's been signed by the buyer's representative. And apparently it's been agreed to by these people here because they're on there. So this would be an agreement that the broker has with them. But, they put them on that they are. So they're part of the contract too. There's all the parties to the contract. Go take this and give it to the judge and tell them that your title insurance hasn't, or your, the title hasn't been transferred, judge. And then we'll give you my buyer protection letter, if you're in a foreclosure. And we'll find out because in 12 days they want to sell Terry's house. It's on the block, well, actually on the 12th of February. So we're scurrying right now with some of this information, see what we can do. So stay tuned for that. So that was that. Now, what does one look like? You can find them in all sorts of ways, but this was just easier for me at the time because I already had it. All right, they had a ALTA form from 1987. Right, so that's one form. And then they have one for 2006 or newer. We'll look at that one because, well, it's probably more relevant. Here. So, Alta closing protection letter. Blank title insurance company. When title insurance of blank title insurance company is specified for your protection in connection with closing of blank state real estate transaction, in which you are the lessee of an interest in land, purchaser of an interest in land, or lender secured by a mortgage. Right, so you're the purchaser of an interest in land. That's you. You're covered. This letter covers three different people: lessee, purchaser, and the lender. They just talk about the lender, which is really the last one, but it's just one of the parties. Failure of issuing agent or approved attorney to comply with your written closing instructions to the extent that they relate to the status of the title of said interest in land, or the validity, enforceability, priority, or lien of said mortgage on the interest in land, including the obtaining of documents and disbursement of funds necessary to establish such status of title or lien. Right? They got to get you the right paper. And in this case, they're putting an inferior warranty deed into the public record. Well, that's either an error or it's fraud. Right? They can fix it, and pay for the damages, or it's fraud, and then go to jail. Someone else will fix it and pay for the damages. But that's their choices. So, well, again, I'm not going to read this whole thing, but I'm going to say, hey, what you're doing is fraud unless you fix it because you've omitted material facts. And that's what makes it fraud. Okay. One more time. Give me a second here. Okay, so here's an example. Let's look at an example. This is Jeff's warranty deed out in Arizona. where it says for consideration of $10, another valuable consideration, I or we, right? Some legal fiction that they made here, because that really isn't any man's name. They're using a middle initial, right? It doesn't comply with the full legal name of the Real ID Act, which you can find at 6 CFR, Code of Federal Regulations, Title 6, CFR 37, and 37.3 is the definitions, and it will define what the full legal name is. First name, middle names, last name, or surname, no initials, no nicknames. Hey, they got initials. And, you know, the fact that they have a comma in there, well, that your name doesn't have any commas. So they've created these legal fictions to replace us. That's number one. But number two, it says do or does hereby convey to. So this conveys, but it doesn't say that it warrants. And you say, well, yeah, well, how do you know that? Well, because here's the law from Arizona Revised Statutes, Title 33, subsection 402, forms of conveyances, right? So in your state, look up what kind of forms for conveyances there might be. And here we have quit claims, conveyance, warranty, or mortgage. And, hey, convey, for consideration of, I hereby convey to A, B, the following real property. Well, that's kind of what it said. But to convey and warrant, because it's supposed to be a warranty deed, right? That's what the contract said we were going to get, not a convey deed, no, a warranty deed. Well, then it has to be to convey and warrant. And it would say the same as the preceding, adding, right? And I warrant the title against all persons whosoever. A pretty simple thing to comply with, and yet, as you can see, it wasn't done. So if you were to take these things into court, the judge would fine for you. Guaranteed, because you got a contract. Right? You will win. There's no way you can't win. Right? We're going in and we're arguing shit in a court case where we're not on the property. That's the problem. Right? The problem happened at the beginning, not in the foreclosure or when you're paying your taxes and things of that nature. That isn't where it happened. It happened at the beginning where they didn't transfer you the title. And there's the evidence that they didn't transfer you the title because it doesn't say that it warrants. And that's what the Arizona Revised Statutes say, and they are the law of the land in this particular case. Well, that's pretty simple. Right? So this isn't difficult, but this was interesting. So this is the deed of trust for the same thing, and when Jeff went to get these papers, he went to the Register of Deeds office or county clerk or however they do it in Arizona and said he wanted certified copies of his stuff. And well, he got copies of his stuff. I don't know if he asked for certified because this didn't have a cover page on it, so I'm not going to say he did. But he asked for copies. Well, this hasn't been recorded. Look, there's nothing up here in the right-hand corner. It is on the warranty deed, right? It shows it's been recorded. But this deed of trust has never been recorded, so how could you ever be liable for it? It was never recorded. Right? It's not a mortgage. It wasn't recorded. That was another thing that was covered on in this protection letter. Right? So the status of the title to said interest in land or validity, enforceability, and priority of the lien of said mortgage on said interest in the land. Well, there isn't any validity, enforceability, or priority because it was never recorded. And the warranty deed is, it's the work of scribes and Pharisees. It's got Scrivener errors. It needs to be corrected or it becomes a felony and they need to be arrested. But this is their chance to cure, right? And this is why you take it to mediation first, right? Go to your brother first. Establish all the facts by 2 or 3 witnesses, and then if you need to, take it to court. But the first thing to do is send something to your local association to give them an idea what's going on. Show them a copy of this, show them a copy of the law, and say this wasn't properly conveyed and warranted. So the title is never transferred. That they have a fiduciary duty to, what's the word they use? When you wanted to finish the thing, right? They got a duty to satisfaction. I have to go back and look. Anyways, they have a duty to finish up the deal and give you back your money. I just can't think of the proper term. So, okay, give me a second. I'm going to get some more stuff. Possibly. Alrighty. Now in Wisconsin, because I don't know if every state's the same, but in Wisconsin I was able to find where you actually have a buyer agency agreement before you have a buy purchase, or what they call an offer. Right? So the offer is the thing that somebody's going to take on your behalf to the seller. But prior to that, you went to an agency to go buy a house, and you're going to do a buyer's agreement, right? To make the buyer become the buyer's agent, right? So I don't know, I haven't bought a property in a long, long time. I don't know how they do it, right? But if somebody's bought property recently in Wisconsin, maybe you remember seeing this piece of paper. What do they make you do when you go to the office and you want to buy a house? Right? Da 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 da. I don't plan on reading these things, but I'm just showing you that they exist. Your firm may, with your authorization in the agency agreement, engage with others, sub-agent firms, to assist your firm by providing brokerage services for your benefit. The sub-agent firm and the agents with the sub-agent firm will not put their own interest ahead of your interest. A sub-agent firm will not, unless required by law, provide advice or opinions to other parties, and doing so is contrary to your interest. Right? So they won't talk to us, but they'll talk to your agent. That's how I read it. Dispute resolution. Buyer means a party executing this agreement for other than rental agreement, and a client. So don't let them call you a client, right? You're not their freaking client. You're a buyer. You're the, what's the word they use in principal agency? Because a client acquires an interest in real estate by rental. And a buyer gets it every way but by rental, other than by rental. You're not renting jack, you're buying. Right? And that's the difference. A client could get it by a rental, and a buyer could never get it by a rental. So that there's no disputing who you are the buyer. A person acting on behalf of a buyer means a person joined in an interest of the buyer or otherwise acting on the buyer's behalf, including but not limited to buyer's immediate family, agents. Right? All these people could have something to do with this thing. Oh, don't want to be a tenant, because the tenant's the one that got it by a rental agreement. Hey, they put that on people's paperwork, that you're a tenant. Think about that. They're treating you like a client, not like a buyer. Well, they were incorrect. You went to buy, not to rent. I mean, this thing's long enough all by itself, and you haven't even bought a house yet. So you get all this thing done, right? And they got all this stuff for the client's signature, and then they got a place for the firm and the agent's signature, right? But here on 351, they have an X, authorized signature, print, name, and title. They are leading you to be a client. Well, what you want to do is be a buyer, and that would be you here. Print name, Robert Allen Rutluski, comma, buyer. That's who you are in this deal. You're not a client. Ain't that sneaky? Them jots and tittles, they always show up. But this is the piece of paper that they would say, well, we're going to take this and give it to the seller on your behalf, and if they sign it, hey, you just bought a house, right? Agent of buyer. You may not even sign this thing. They may fill it all out for you. You never even know it existed because you already made them your agent. Delivery of documents, unless otherwise stated in this offer. Delivery of documents and notices to the party shall be effective only when accomplished by one of the methods specified in 36 to 54. right? Buyer's recipient for delivery. That's optional. Delivery address of buyer, seller, receipt. Okay, goes back to 38 or 39, right? Well, that's either the buyer's recipient for delivery. Either it's you or it's somebody else. And that's how they get you out of the picture, so now they get to do all the mail. And all this stuff is going on, and you don't even know it. Real estate condition report. Why am I? Default, seller and buyer each have legal duty to use good faith and due diligence in completing the terms and conditions of this offer. Material failure of this perform this obligation of the offer is default, right? Such defaulting liable for damages and other legal remedies. Well, that's excellent. Specific performance, that's what I want. Buyer may sue for specific performance or terminate the offer to request return of earnest money, sue for actual damages, or both. Well, that would be probably what we'd be doing. Evidence, right? So no matter what yours looks like, your buy-sell agreement or whatever they call it, eventually you want to find out, well, how are we going to know if we transferred the frickin' title? And in this case, it says here, seller shall complete and execute the documents necessary to record the conveyance at seller's cost and pay the Wisconsin real estate transfer fee. Now, the reason we know that Terry's wasn't paid is we had tried to do a change or a correction on her warranty deed. Fix the Scrivener errors. I did a video on it some videos ago about Scrivener errors. Well, when she went there, the clerk said, well, you can do it, but you would have to show me a receipt for the Wisconsin real estate transfer fee. Well, it's like, well, why would she have to have it? It's supposed to have been done by the seller. Well, here's the evidence it was supposed to have been done by the seller. And they're saying they don't have it. So I'm saying, well, if you ain't never seen it, then it ain't never transferred. And so, hey, we're going to go check on that. So, based on this, blah, 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 earnest money, right? That's the little bit that's held in a trust account that we would use as the initiation point to say, well, if, we get the earnest money back, that means the deal never happened, and we should be able to foreclose for damages. If you were able to get that judgment from a small claims court that said they're going to give you back your earnest money, which would be here on line 10, I would have to think there's a way to get the rest of it back, and even an attorney would be glad to help. Because it's going to have been done in fraud, and now there's going to be 4 times damages. And technically, you should get 2 of those, because one of them is yours as the injured party. One is yours as the informant. One goes to the prosecutor, which is the attorney you gave it to, and I think one goes to the court. Is that how that works? Right? They take the 4 and split it between other parties. So what did we do? Well, because, right, foreclosure scheduled. Terry just sent this to me. So, hey, Terry, yeah, I see. Yeah, on the 13th, basically, February 13th, her house is up for auction. We'll see if it goes off of the schedule because of what we did. And so what we did is we faxed the local Realtor Association, right? And this is as simple as putting in the name of the county and say Realtors Association, and boom, takes you to a page. And they had a fax number, so well, let's send them a fax. So I wrote this for Terry, and then sent it using what do they call it? Fax 0, like she had sent it. So I am Terry Lynn Wilson, the buyer of certain real property. The address used by the post office for this property is 1734 E Road 4, Egerton, Wisconsin, with a 4-digit zip. First Weber Realtors is the buyer's broker. That's whose office she went into to buy the property. So let's tell them who it is. I have been made an unwilling participant and victim of a simulated legal process under color of law, which is Rock County case number 2018 CV 000136, Ditech Financial LLC versus or VS Terry L. Wilson et al., by which individuals are attempting to unjustly seize my property. I have asked my buyer's agent, right, the broker, representatives from the broker's Middleton, Wisconsin office, because this First Weber is actually in some other place, but they have an office in Middleton, Wisconsin, for numerous documents associated with my purchase of this real estate and the transfer of all the rights, titles, and interests in the same to me to use in my defense. It is my understanding that notices and documents intended for the buyer are in the possession of the buyer's agent, that would be the broker, including a closing protection letter for frauds committed during closing, and the title insurance for the buyer. My buyer, agent, broker, has failed to provide any documents thus far, and I asked the REALTORS Association's assistance in compelling the buyer's agent, the broker, to execute its fiduciary duties to the buyer. That would be me, Terry. Rock County case number 2018 CV 000136, Ditech Financial LLC vs. Terry L. Wilson et al. Is a simulated legal process and a felony crime against the United States that the buyer's, my agent, broker, is aiding by not having fully accounted this real estate transaction to the principal, me, Terry. Please see to my relief today, or I will be forced to seek arrest warrants for federal crimes and informing the circuit court judge of the ongoing case of the omission by members of the REALTORS Association that are allowing the fraud to proceed. I need the following emailed to my email address of her email address, the broker rendered account of the sale, all notices and documents intended for the buyer that were delivered to an agent, the broker. This matter is time sensitive, so please respond immediately. So we sent that on Thursday. I think that was the 31st. And then Friday, Terry called them and said, hey, I need your help, guys, da-da-da-da. And that's when they said they would have an advocate call. Not an advocate, dang it. An ombudsman. Ombudsman. Let's look up the definition of ombudsman. Buds. They don't have it on there. Can you imagine? I have to go to where are you? Where did I see it? Well, I just have to do it this way. An official appointed to investigate individuals' complaints against maladministration, especially that of public authorities. All right, so that's an ombudsman, according to the definition, is an official who is charged with representing the interest of the public by investigating and addressing complaints of maladministration or violation of rights. So they shouldn't cost you anything. Right? So this person is the one that should investigate your complaint. And so that was good news. Like, okay, well, let's see what the dude has to say. See what he comes back with. But in the meantime, because they couldn't do it on Friday, I said, well, let's go ahead and write to the judge. So Terry Lynn Wilson, sole proprietor, 1734 E Road 4, Edgerton, Wisconsin, blah, blah, to the honorable judge about this case and the closing protection letter concealment. Dear Judge McCrory, it has come to my attention that my buyer's broker, for the real estate transaction regarding the premise at 1734 E Road 4, Egerton, Wisconsin, has been negligent in its fiduciary duty to the buyer, that would be me, of said property. The broker for this transaction is First Weber Realtors at their Middleton, Wisconsin office. There it is. I tried to have various Scrivener errors corrected on the recorded warranty deed of the transaction in question and was told by the county register of deeds that I could make the corrections, but first I would have to provide her a receipt showing that the real estate transfer tax had been paid. Judge McCrory, I was asking to correct a record, not record a new one. So there's no reason for me to provide a receipt for the register of deeds. It was the duty of the seller to provide the receipt. Then it had occurred to me that I had never received a copy of the receipt from the seller, and my research of this issue has led to discovering that a number of other notices and documents intended for the buyer have gone to the buyer's agent on behalf of the buyer, but were never forwarded to me or to the buyer. That would be me. Specifically, I did not receive buyer's closing protection letter. I believe this letter is receipt to my is the receipt to my title insurance that will indemnify me regarding these proceedings in your court, and I have been coerced in participating in, because the Rock County Register of Deeds does not have the receipt for the real estate transfer fee. I believe that the real estate transaction was never been executed to completion, and that my broker owes me a fiduciary duty to complete the transaction in my best interest to protect my rights, titles, and interests and pay for damages done to me and my property. I am including a letter I have faxed to Rock Green REALTORS Association, and we just saw that, asking for mediation, and was told on February 1st, 2019, that an ombudsman would contact me when they returned from vacation. Judge McCrory, I am asking you please intercede on my behalf, or on behalf of justice, and resolve this matter once and for all based on the terms of the sales agreed to by agents of the transaction. I leave it to you to decide how to proceed. Terry Lynn Wilson. There's no reason the judge can't call these people in to come answer some questions, right? Cancel the sheriff's sale, right? That's nothing. I mean, this sheriff's sale can go away with one phone call. If there's any controversy, it'll go away. And the one that can make a lot of controversy is the judge. And the judge could just solve the whole matter if she was just given the right information to work with. But right now, she's been handed a turd, right? It's all this paperwork for a foreclosure that doesn't have anybody's signature on it. Nobody's using their full legal name. It's all been done in fraud. The whole thing is a joke. And it's because the people that did the closing never transferred the title. The evidence of that is the fact that there is no receipt for the real estate transaction fee. And there doesn't have to be anything else. That's enough. I don't need any more reasons. I'm not going to go look for any more. Right? I'm just going to tell my agent, what she did, hey, we got a problem. And the agent hadn't responded quick enough. So now go to the, right, that was your brother. Now go establish witnesses. Go ask for mediation from the Realtor Association. And if that doesn't work, go to court. But because Terry's already in court, well, we'll just fast track it. Do them both at the same time. Any solution that's correct would satisfy both the civil and the administrative. So, we're happy with it. Could be an interesting week next week. And so to see if anything changes, right, if you were to go to Wisconsin Circuit Court Access, which you can find quite easily, and they would have a place to put in the case number, which is 2018 CV 000136, right, 3 zeros and then 136. You'd see this case here, which says it's closed. It says all sorts of things. But when you get down here, it says what the last event was. So on the 14th of January, a transcript for motion hearing. Hey, Terry, you need to go down to get this. Transcript for motion hearing held November 26th in front of Judge McCrory was put into the record. You should get a copy. Right? But as we stand now, right, there was a sheriff's sale supposed to go on. So we mailed a letter. Let's see if there's anything that comes up 02- someday next week, 2019. and see where we are then. Okay, that's one style. I'm going to show you one more. And that will be enough, I do believe. So give me just a second. Hey, I just realized I didn't cover this quite good enough yet. So hang on just a second here. So here's warranty deed. Right? And I showed on the closing paperwork where they had changed the address. Right? So basically what address they were using is in the legal description. So here's a warranty deed. Right? See Exhibit A. And Exhibit A calls it Lot 16 of Lake Ridge, according to this plat, da-da-da-da-da. Right? So this address would be Lot 16, Lake Ridge. Right? And the mailing address would be, well, whatever street address I gave that to that. But that would be your top line of your address. It's Lot 16, Lakeside Ridge. And I don't think you need to put Plat or anything else. It's just, those were the elements. Lot 16, Lakeside Ridge, the part that's been highlighted, emphasized for your use. So that's that kind. And then let me see. We're going to look at Dana stuff now. Here's another style. See now, for instance, here's the property address, 204 George Street, right? But the legal description is Lot 9, Block 11, Suite Addition, Village of Kalkaska, Section something or other, something or other. So I think what you'd have to do is you go find the plat at this would be in the Village of Kalkaska, go look at their maps, find your plat, your lot on there, and see what the name of it is. But it's probably Lot 16 or Lot 9, Block 11, Suites Addition. That would be the line that replaced 208 George Street, right? This is the mailing address, 208 George Street, for lack of a better term. We'll say it's a mailing address. But the government lot, and that's what they call it, the government lot is Lot 9, Block 11. Well, that ties you to the land because that is the Public Land Survey. Public Land Survey. So what's happening in Dana's case? Dana's got a lot of things going on, poor guy. Notice to show cause in judicial foreclosure hearing for not paying his property taxes. A show cause hearing will be held at some time, 1/22/2019, 10 a.m. Well, as it turns out, when you have a show cause hearing, for taxes, it's with the treasurer, right? It's not with the court, it's with the treasurer. And then if they're not satisfied, well, then there'll be the circuit court foreclosure hearing was another date. And that has a docket number. So that has a court docket number attached to it. But it starts out with the treasurer, right? And so they're saying that the owner of this property that's being foreclosed on is Smith Dana R. Right? But if we were to look at the warranty deed for this property, we would see it was to Dana R. Smith. Right? So, hey, can you do that? Can you change my name around? I don't think so. First name, middle name, last name. No initials, no nicknames. So this is still wrong. But if this is wrong, then this is certainly wrong. Right? Smith Dana or Smith Dana R, that doesn't mean. You can't charge me in that name. Right? You need to use my full legal name if you're going to say I owe you something. If it's going to be legal, you need to use my full legal name. But because there's nothing legal with this, well then, that kind of gets thrown out the window. But I wanted to show this. So Dana went and asked for a certified copy of his warranty deed. So Joanne DeGraff, Kalkaska County. Where? Kalkaska County. Doesn't say County of Kalkaska. It says Kalkaska County, Register of Deeds. I, Joanne DeGraff, Register of Deeds for the County of Kalkaska. Now, how can that be? They just said Kalkaska County, but now saying County of Kalkaska. Well, because this County of Kalkaska isn't the name of an entity. It's two proper nouns connected with an of. But it's not, right? So it's the organized County of Kalkaska is called Kalkaska County. When it was an unorganized County of Kalkaska, just a thing on a map, right, it would be lowercase c, County of Kalkaska. Right, there's the name, and now we're going to organize it, and now it will be an organized County of Kalkaska, and its name is actually Kalkaska County. Right, but it's not County of Kalkaska. I know it's a little bit difficult to understand because it's grammar, and, well, they don't teach that in school. But she's, under her hand and seal, witnessed by my hand and seal, affixed here too, at the County of Kalkaska. Well, what seal did she use? She used the seal for Kalkaska County, Michigan. Right, so this is an official seal of the proper state entity, because Kalkaska County is an administrative arm of the state of Michigan, and whenever the inhabitants of the territory that had been called lowercase County of Kalkaska reached a certain amount, they would be organized, and they became Kalkaska County, not County of Kalkaska. Well, she's the one who's, saying that this is a true and correct copy, and this is supposed to be the real estate transfer fee stamp, but this wasn't applied to this or affixed. It was imaged. Right, when they printed it out, it came out that way. They didn't start with an original stamp. And as we'll see in the law, it says you have to affix a stamp. It doesn't make any provision to have it done electronically. Regardless if you agree with that or not, has this stamp been canceled? Nobody's written across it, right? They wrote over here, but, okay, that isn't where it stops right here. This is the edge of the frickin' stamp. It ain't been canceled. So we've had this discussion with Kalkaska and got their answer. And Dana has to go to court on the 5th in front of a judge that he just had a hung jury in front of for a felony case, who had said to Dana's attorney in there, he says, I can't believe these people can't make a decision. Something to that effect. He says, if they find him guilty, I'm only going to give him a fine. Or I may not even give him a fine, something like that. But there won't be any jail time. And so that's what he told him. He said, the judge says there won't be any jail time. But, you can't believe that they haven't, whatever the words were, that they would find you guilty. Well, they didn't. It was actually 9 for Dana and 3 for the prosecutor. And the issue was, had there been any arrest warrants at the time of their barging into his door? And the 3 cops called to the stand when asked the question, did you have an arrest warrant? All said no. So it should have been an unlawful arrest. Instead, it's a hung jury. And that's the way you keep it from being an unlawful arrest. Just have somebody say, I ain't changing my mind. It's a hung jury. That isn't what's happening here, but it's the same judge. So this judge is going to hear this case on Tuesday is well aware who Dana is. So when Dana comes in and says, well, Judge, here's my warranty deed. This hasn't been canceled. Look, there's stars right here. I say that's where that ends, and it hasn't been canceled. Judge, here, let me read you some law, which I'll get in just a second. So part of our going back and forth was we had asked the treasurer's office if that stamp there had been canceled. And the treasurer sent it to the Register of Deeds, who said, good afternoon, Mr. Smith. I received a copy of your email from Treasurer Thornburg with a copy of the certified copies I signed on January 23rd when we received the document over the counter or by mail for recording. Our office collects the real estate transfer tax unless an exemption code is utilized. Once we record the document, the transfer tax is printed simultaneously and contains the corresponding document number. The date of our staff initiates the date, and our staff initials the stamp. The handwriting you see on the rectangular stamp is the initial of a former employee's and makes the stamp unusable a second time. I understand your concerns, but please know I would not accept a document for recording that the pre-stamped with transfer stamp being paid. I would not accept a document for recording that was pre-stamped with the transfer tax being paid. I'm hopeful I've answered your question, but would be happy to discuss further over the phone or in person. Stay safe and warm. Oh, we're gonna be back to you, Joanne. Because it said that she collected it, but it didn't say she paid it. You know, so if you're thinking about a register, right, when you give money to the person at the register, they put it in the till before they hit sale, right? So it's been collected. It just ain't been registered. Haven't had a sale yet. That's what I believe happened. But let's look at what the law says, right? So she said, yeah, it's been on, and they did it at the same time, and yada, yada. Sounds really good. Yeah, I'm almost convinced. I was almost convinced. I said, I got to go read that law again. Where did I put that? Oh. Oh. I have to. Oh, and the treasurer says both acts have been complied with. Now, give me just a second. I'm going to have you wait while I'm looking for this stuff. So this is what those laws had said. There's actually, for whatever reason, we have two laws in Michigan. We have the Real Estate Transfer Tax Act of 134 of 1966. And the State Real Estate Transfer Tax Act, Act 330 of 1993. And in both cases, it says that the tax imposed by this act shall be evidenced by affixing of a documentary stamp or stamps to every instrument subject to this tax, by the person making, executing, issuing, or delivering such document. Documentary stamps shall be purchased only in the county in which the property is located. The stamp shall be affixed in a manner that their removal will require continued application of steam or water. And the person using the affixing the stamp shall write or stamp thereon his initials and the date upon which the stamp was affixed or used, so that the stamp may not be used again. The treasurer may prescribe other such method of cancellation as he deems expedient. The treasurer shall, if required by state treasurer, utilize a tax meter machine, which shall be provided by the county. It has to be a stamp and put on the paper. And this thing is imaged on here. That's what she said, that it was imaged, right? It was imaged when they put it in. But it wasn't canceled. This isn't on the stamp at all. No. That ain't going to work. That's what that law said. Preparation of stamps, duty of treasurer to use the stamp machine. The state treasurer shall prescribe and prepare for use by county treasurer adhesive stamps of such denomination and quantities as shall be necessary for the payment of the tax imposed by this act. The state treasurer shall prescribe conditions on which county treasurer may utilize a tax meter machine, but it's still a frickin' stamp. The adhesive stamp, if used, shall be requisitioned by the county treasurer as required. The county treasurer shall reimburse the state treasurer for production cost of stamps so requisitioned. The treasurer shall make provisions for use of a tax meter machine or for the sale of stamps in such places as he deems necessary. Where's the tax meter machine? So that was one act. Well, here's another one. except as provided in 9, the payment of the tax imposed shall be evidenced by affixing a document stamp or stamps in written, blah, 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 blah. A stamp required by this act shall also serve as stamp required by the act we just read. Affixing. So I'm saying they have to affix them. Right? So I'd be taking these two sections of law in, and a copy of this document right here that's been certified by the clerk is being, this is the record, and have the judge make the determination of the fact and law. Right? Was this stamp canceled or not? Yes or no? If this stamp was not canceled, then Dana don't owe these taxes, because it's not in his name anyways. But he's been paying taxes for lots of years, so he should be able to get the judge to give him a check. Say, Judge, tell the treasurer, give me a check. Those aren't my taxes. They never transferred it to me. Right? I'm not saying somebody doesn't owe them, but it isn't me. It's, whoever the bastard is that didn't transfer the property. Those are his taxes. And so this is supposed to be a warranty deed also, and I don't think it says on, well, no, this is a quick claim deed. He had another one that was a warranty deed, and I don't know that it said it warranted and conveyed on there either, which is another thing. The point is, right, that well, it ain't right. And as bad as all that looks, you know what I've learned out of this is, hey, this is where your freaking address is that you need to say is your residence address to put you on the land. Lot 9, Block 11, Suites, Addition. Right? If it has to be the whole thing, well, so be it. But I think it just stop there, Suites, Addition. Because then it's Kalkaska anyways. Right? That's what this is, Kalkaska County, or Kalkaska, comma, MI, 49646. Well, that is the village of Kalkaska. Very interesting. We'll see what happens with that next week. Okay, I don't know that there was anything else I could show you today on earnest money and closing protection letters, but they're the key is your title's never been transferred. It doesn't matter if you're in foreclosure or not. Your title ain't been transferred. You're paying taxes that aren't yours. They don't use your name. They put your name backwards, say it isn't my name. That's not my full legal name. It's been defined. And you can go talk to these people in these offices, and they just don't seem to care. Well, the problem is you're not using the right address to say where you're from, right? We are not in the United States. We are elsewhere. In fact, I'm going to show you some more evidence that didn't have to do with this, but hang on a second. Pause. Okay, I'll soon be doing a whole nother video just on this subject, because this has to do with the Veterans Administration and us veterans. And anyways, they wrote me a letter to Robert Rutlewski. Well, that's not my full legal name. So, and this really isn't my mailing address, because if it was, it'd have -8664 there. And they can't put it on there for some reason. I really think this has to have that lot number and whatever I'm on, and then Rockford, Michigan 49341. Right? I got to find the plat that I'm on and put that information where this is here as a residence address. But forgetting that for a second. Or they're just doing this on purpose, because when they send this to me, it comes in an envelope. This is like the third one of these I got now. And they're with the Office of Inspector General right now, where this says it's a official business penalty for private use envelope that's misaddressed to me. Well, that'd be a violation of 18 U.S.C. 1342 and 1341 as far as that goes. And it doesn't have any mailing stuff up here, right? So it wasn't sent first-class mail. Right? There's no sticker. There's no, where's the meter machine? Where's the thing that says U.S. first-class mail? No, it wasn't on there. This envelope was stuck in this, I'll just leave it this way, this flat UPS delivery, right? Battle Creek. Right, Battle Creek, VAMC, some address. And ship to Robert Raluski at this address, 49341. See, this one has a +4, and I don't. You see that, right? Now watch this. When you go and you look at the UPS delivery of this tracking, when the label was created, it was created in the United States. And it was shipped from the United States. It did all these things, but when it was delivered, it wasn't delivered to the United States, it was delivered to the U.S. Well, what's the difference in the addresses? Theirs is using a +4, and they're sending it to one that doesn't have a +4. Yeah. So, they're not sending it to you domestically. They're sending it to me, this mail, like I'm not in the United States. And if you're not in the United States, you're not protected by the Constitution. They would like you to believe. If you're in the military, you're supposed to be. Right? That's what Lindsey Graham and at the time, Justice-elect Kavanaugh were talking about. Where do your constitutional rights go? Do they follow you to Afghanistan? Right? Or wherever it is. Yes, they do. And that we are right now under the laws of armed conflict. Yada, yada, yada. And at the end of the day, this will all get figured out because the veterans will use the VA for the way the VA was intended. To first do that, we need to, get rid of some dead wood. And whoever did this committed a felony. So I've already taken this to the director of the Battle Creek Veterans Administration Medical Center, who did forward it to the Inspector General. But the Veterans Administration also has a police force. And I'm just going to get a hold of them and give it to them directly. And you know why? Well, because I can. We'll find out. But I'm just showing you this to show you that, this is the thing that we're not being found in the United States. And so somehow we got to get ourselves on the land. And one of the ways I say they're keeping us off the land is by the fact that they're not transferring the title to us. And that we're not using this legal description, right? This is legal, legal description, Lot 9, Block 11, Suites Edition, as an address for the residence address on like your change of address card or your driver's license form, state ID form as the residence address. And then when they say, is the mailing address different? You say, yeah, it is. It is different. And I'm going to say, well, so this would go on anything you got to give them a residence address for, and that would include, I had done gotten an EIN number, right? It's a sole proprietor, but I use my mailing address in all the places. As soon as I figure out what my legal address is, I'm going to, put in the paperwork and change it. Okay, let's leave it there. You all take care. I really hope that you found it useful. And I really hope you'll please donate because I'm going to be 2 months. I am 2 months behind right now. 2 months behind. I can't pay I might be able to pay my electric bill, but I can't pay my my cable bill. So I won't be doing any more videos. That'd really be a shame, people. You don't want that to happen. So help me out. See you then. Bye-bye.